I'm writing lines to lift his name, no need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, let's amplify. I am spreading the faith I hold so dear. For every tear he's ever near. Choirs rise on Sunday morn, his love we adorn. Each melody a testimony, hearts reborn. In every verse a whispered prayer beyond compare, to lift the hearts of those in dark despair. We testify with every note we sing. In harmony let freedom's bell ring. Rejoice and lift your voice, let the sound of praise deploy. Marching to his beat we go, faith the seed we're here to sow. A standing strong through trials, love's chapter will compile. A beacon shining, grace defining across the mile. In our stories his glory shines, a light divine. Through the gospel groove his truth we move, lives alive. Each Sunday pew, a vessel lined with grace anew. Souls intertwined, the word defined, it shines on through. Lifting high the cross we bear, in solace share. Hey, hey. The hymn we breathe, in him believe, it's love we declare. We're saved by grace in this old levered place. Voice is strong in this soulful song we embrace.
Hello, everyone. Welcome to SAVEDNews TV. I am your host, A.Z. Hubbard. Thank you so much for allowing me into your homes this evening. And we have more information on the Jakes versus Youngblood case. Now, I just did a video. I've done several, but I just did a video where Youngblood had petitioned the court for an extension for to reply for the case, okay? And in that, he requested the court to give him an extension so he can get a local attorney. However, like I said in the other video, it might not have been a good idea for him to represent himself because in his request for extended time, he put his entire game plan and what he planned to do in an extension for time. Those are two separate pleadings, different pleadings, and he really might have just totally messed up himself. Well, needless to say, TD Jakes' team wasted no time. They were on it. They filed a brief requesting that the court reject Youngblood's request for additional time, and it was done like minutes after I posted my video. It was like boom. I was like, oh wow, now I have to come back and do another video. But anyway, it is amazing how swiftly they answered. I mean, it's unbelievable. But anyway, like I said, Youngblood might have made a major mistake, and you'll as we get into reading the case that the petition that Jakes responded to, saying, please don't judge, extend his time because we gave him that opportunity. I will also be doing commentary in there because there's so much in this case so far that I'll be able to keep you all up to date. So I will not be reading it straight through. I will be commenting in the interim of it also. But anyway, also the judge did rule on this. So what I will be doing at the end of the video, where, well, doing more commentary after I finished reading it, and the case, praise God, is not that long. But I will also let you know what the judge's decision was. But anyway, let's get into this read, okay? And commentary this time. All righty then, let's get to reading. And this was filed today, December 23rd, 2024. Thomas Dexter Jakes versus Duane Youngblood and John Doe 1 through 10. Opposition to Duane Youngblood's application for extension of time to respond to the complaint and the motion to strike pursuant to FRCP Rule 12F. Plaintiff Thomas Dexter Jakes, hereby plaintiff as Bishop Jakes, by and through his assigned counsel, files for the opposition of Youngblood's application for the extension of time to respond to the complaint in this case, and makes motions to strike scandalous and obviously false materials pursuant to FRCP Rule 12F. Now, right here is where I said that Youngblood made a critical mistake by putting all his plan inside of his request to extend time, because depending on what they want to strike, that means that anything, if the judge rules in the favor of Jakes to strike this information, that means that there will be no anti-slap case, depending on what they're asking to be struck. He said in his original filing that he was going to bring 7 affidavits. If the judge, depending on what they're asking to be struck, if it's struck, then that means that he cannot bring that evidence into court. He will have no case. But anyway, let's get on to reading this. Okay. Simply, defendant Youngblood's submission to the court by letter dated December 20, 2024, ECF docket number 17. Therein, the quote unquote response constitutes a responsive pleading as construed by federal rules of civil procedure and should be deemed as such. Okay. Again, this is a horrific move by Youngblood. In essence, what TD Jake's team is saying, hey, Judge, this was not a request to for time deemed by all the other information and everything he put into that. This is considered a pleading. And it's a pleading because of federal rules of civil procedure and should be deemed as such. Whoa. So again, Youngblood taking the advice of going solo or deciding upon himself to go solo and pro bono on this proceed on his case. You know, he's playing checkers and TD Jake's team is playing chess. They are going to pull the law into this case. And Youngblood is, he's outboxed by himself. This is not, you suing in civil court for $5,000. This is major. And to go into something like this with the money behind TD Jakes and the law team, they're going to whip you with legalese. But let's keep reading. Defendant Youngblood's 11th hour application, based on a purported need for additional time, is nothing more than a delay tactic to further coordinate with his co conspirators by creating a mechanism to avoid dealing with plaintiff's motion for expedited discovery. And as a general matter, move forward with this case and to improperly lob salaciously false and irrelevant material at plaintiff. For this reason, for these reasons described below, the supported by declarations of attorney Darrell Janey, this delay tactic should not be countenance. Wow. Relevant and factual, relevant factual and procedural background. As this court is aware, the complainant in this case was filed on November 25th, 2024. Counsel for plaintiff made a couple of attempts to coordinate service of the complaint and related papers to defendant Youngblood with the person then purporting to be defendant Youngblood's counsel, attorney Tyrone Blackburn. Even though counsel for plaintiff offered defendant Youngblood an opportunity to waive service, which in turn would have permitted him 60 days to respond to the complaint, defendant Youngblood responded, "Chase me if you dare." Woo! Okay. Okay. I guess they're getting ready to chase him. So this is why, you know, they're saying, "Judge, please don't give him more time." But he would have had 60 days versus the 30 days that he's requesting. But anyway, like I said, he's playing in the big boys court now. Defendant first rejected that offer on November 25th and then again, quote unquote, doubling down on his antics when counsel for plaintiff reiterated its offer on December 4th. Ultimately, plaintiff was able to achieve service to defendant Youngblood on December 4th, more than a week after filing the complaint, and following successive requests to coordinate that would have given the defendant more time. By and through his gamesmanship, defendant Youngblood failed to obtain the time he now seeks. We submit that defendant Youngblood should not be rewarded now for any of his brazen and apparent arrogance. Prior to successfully serving defendant Youngblood directly, counsel for plaintiff received several emails from defendant Youngblood's counsel on December 4th. Those emails articulate a plan to, among other things, file an anti-SLAPP motion against plaintiff and secure several affidavits under penalty of perjury to be used against Bishop Jakes. See, this is what I'm talking about right here. When they said um his he told them what he had planned on doing, that he had planned on filing his email. He's going to file an anti-SLAPP. He's going to secure the affidavits for perjury to be used against Bishop Jakes. So he, he's shown his whole hand. Now, what is his defense? You know, what is his defense? Tell me in the chat how you feel about this. What is his defense? The plan described in counsel's December 4th emails in sum and substance are not different than what the defendant Youngblood describes in his response to the court in his current submission. On information and belief, even though Defendant Youngblood describes his status as pro se. Attorney Blackburn continues to work with him and advise him as counsel. In part, we submit that the reason that defendant Youngblood carefully states that he is, quote unquote, in the process of attempting to retain local counsel, emphasis added. The issue is not that defendant Youngblood suffers from the need for counsel. Rather, on information and belief, the defendant is facing a two-pronged problem. Okay? So I don't know how many of you follow the Diddy case or some of these larger cases out here. The name Tyrone Blackburn should sound familiar to you. And so if you do, that is who he asked to be on the case. So when he says a two-pronged problem, Attorney Blackburn does not have the best reputation, but we're going to read into this now more detail. First, on information and belief, Attorney Blackburn is having difficulty getting sponsored by local counsel to support him for admission in the Western District of Pennsylvania, given admonishment by federal district court judges in response to counsel's conduct. Okay. So I don't know how many people know how law works. You can have an attorney, like I live in North Carolina. I can have my if I am in New Jersey, say, and I want my North Carolina attorney to represent me, or my New Jersey attorney to represent me in North Carolina, then what they do is the attorney from out of state go underneath the license of another attorney. Well, because Mr. Blackburn has had some issues, it appears that no attorney in Pennsylvania want to allow him to come underneath their license. You get it? So, so he can't practice in that state. Um, until if he doesn't get somebody to allow them underneath his license, then Youngblood has a major problem unless he can get another attorney. And who knows if any attorney would pick up this case now, especially the way the request for additional time was filed. Okay, so let's get back into this. For example, on April 3rd, 2024, Judge Denise Coate, District Court Judge in the Southern District of New York, referring Attorney Blackburn to the Grievance Committee of the Southern District of New York, issued an opinion and order stating a reasonable reference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressures defendants to quickly settle. Indeed, his submissions to this court have been rife with disturbing allegations against the defendants and defense counsel. Okay? Second, on December 17th, 2024, plaintiff filed a motion for expedited discovery, requesting approval for the court to issue two third-party subpoenas, which are in turn anticipated to reveal identities of John Does in this case and further substantiate plaintiff's conspiracy claim. Now, in the previous video, we read out the case filing for TD Jake's request for expedite discovery. We also read out the exhibits, which were the two subpoenas um, for a potential John Doe and to gather information. Those petitions were, those subpoenas were to Larry Reed and the Larry Reed Live show. Okay. All right. Let's get back into it. By December 18th, 2024, based on assertions by defendant's brother, Richard Youngblood, on a public podcast, defendant Youngblood is working tenaciously to provide his response to the court to the allegations made in the complaint, and that public could expect that quote unquote that answer within the next week, as the deadline is December 26th is approaching. We submit that what changed between December 18th and December 20th is that defendant Youngblood and his co-conspirators needed to find a way to slow down the proverbial train, according to defendant Youngblood's response, followed by the December 20th. Mm. Woo, argument. A. Defendant Youngblood's December 20th, 2024 letter is a response pleading to the complaint and should be deemed as such. Again, like I said a few minutes ago, that is where Youngblood has, run into a problem, is because he put too much information into his letter. He should have just said, I need additional time, dear judge. I need additional time to get local counsel. Please grant my request. The end. But instead, he put his whole game plan. He put in there that he plans on filing an anti-SLAPP. He put in there that he is bringing 7 affidavits. He put in there photos. He put in there so much stuff. But let's get back to reading this right here. Defendant Youngblood's response constitutes a responsive pleading within the meaning of federal rule of civil procedure rule, because it engages with the substantial issues raised in the complaint and responds to the merits. Again, Youngblood probably needs an attorney. Deciding to go pro se on this, it just, these are not the boys for it. But if you're going to go pro se, it's better to just, get some understanding, see if you can even legal aid or somebody for them to have helped him with that pleading. But that was bad. But anyway, it is no mere request for an extension of time to secure legal counsel. Rather, first, defendant Youngblood specifically argues that Bishop Jake's complaint is without merit, and then proceeds to identify affirmative defenses to the complaint itself. Specifically, in pertinent parts, he states, Your Honor, I have unwavering confidence that the court will discern the lack of merit in the plaintiff's claims, which I firmly believe constitutes a violation of my First Amendment rights. Response 1. He does not provide mere conclusionary assertion. Rather, the defendant cites and elaborates on case law in support of his protected speech defense in New York Times Company versus Sullivan. This is clearly an effort to provide notice on his intended defense and the basis in law for his argument. Wow. Like I said, I keep repeating this. I feel like I just need to record it and just hit play, 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 play. Man, okay. Here, in this respect, defendant Youngblood and his counsel is trying to comport with FRCP Rule 8 by articulating affirmative defenses as the reasons Bishop Jakes could not win. This is the very heart of a responsive pleading. In addition to his protected speech defense, defendant Youngblood raises the scepter of affidavits in support of his quote unquote truth defense to the libel claim. Further, in his 6-page submission, defendant Youngblood articulates and elaborates upon the reason he should fall within heightened protection under the First Amendment because Bishop Jakes is a public figure. Moreover, he raises the affirmative defense of waiver in accordance to FRCP Rule 8C. For example, defendant Youngblood states, despite my consistent and public recounting of these incidents, Mr. Jakes did not see fit to file a defamation lawsuit against me during those many years. This inaction suggests that Jakes himself recognized the validity of my statements or deemed them unworthy of legal challenge at the time. Response 2. Again, this sort of elaboration and detailed reply, while erroneous and ineffective in this case, is the nature and substance of a responsive pleading. Whew. Given that defendant Youngblood has submitted an answer to the complaint, the clock should not stop on the procedural mechanisms that then follow under FRCP in order to move this case forward. For example, we submit that Rule 26 initial conference should proceed and whatever motions defendant Youngblood intends to bring can be discussed with the court at that time without prejudicing the plaintiff by, in effect, postponing the day of reckoning from likely 60 to 30 days, 30 to 60 days. I mean, this attorney is not playing. He has already called that the day, he called it a day of reckoning. Jesus. Defendant Youngblood's shameful assertion that Bishop Jakes is responsible for unaliving should be stricken. Defendant Youngblood states, upon information and belief, Bishop Jakes and his family have a reputation of having individuals who challenge them or expose their dirty dealings disappeared throughout the years. This statement can only be characterized as an allegation that the plaintiff has been engaged in violent criminal activity, including unaliving people. It should be stricken pursuant to FRCP Rule 12F. Rule 12F permits courts to strike any insufficient defense or any redundant, immaterial, impertinent, or salacious matter in the pleading, including the answer. And they quote Thomas versus Keystone Real Estate Group. Such motions are granted where the allegations have no possible relation to the controversy and may cause prejudice to one of the parties. Here, the bald-faced lie that Bishop Jakes have participated in making people quote unquote disappear is salacious at its core. It has no relation to the libel and conspiracy claim in this case whatsoever. Conclusion: Defendant Youngblood's application in reality is a Trojan horse simply intended to undermine the litigation process in this case. If permitted, the application would result in substantial prejudice to the plaintiffs for the reason described here above and within the supporting declaration. Accordingly, we have submitted that the application should be denied. Okay. So he's like, okay, let's just forget about that. Deny the application in whole, judge, and just throw it out. And let's get on with the get on as soon as possible. Now, um, they also included exhibits in the pleading regarding Blackburn. Okay. So the exhibits A and B that includes Blackburn is in the documents. Okay. Now for the legal information regarding Blackburn, I am not going to read that out. I am going to put that into the members only section. So if you're a member of this channel, you can get the link to that information, or you can just, if you're not, you can click join at the bottom. Well, anyway, and the judge did allow Youngblood an extended a period of time of 30 days to respond. However, the judge will be hearing the case regarding the request by TD Jakes for an expedited discovery on January 6th. So this is getting ready to really gear up. It's going to be hot. It's going to be heavy. Everybody, you see how fast and how many videos we're doing on this. So we'll have video probably in the upcoming year on this case. We want to continue to follow this closely. Tell me what you think about it in the comment section. Number one, I believe that Youngblood made a serious logistical error by filing pro se. May the judge be with him. If you look at the last video that I did, and again, I'll link that in the comment section, where I believe, he might have gotten the advice to go pro se. It also has a video in it showing you who said that. And it's hot. So you need to watch the other videos. Okay, so we hope, and I probably need to just do a whole playlist. I generally don't do playlists on stuff, but I probably will need to do a playlist on this because of the fact there's just so much information coming out. I hope that you all really go back and watch, get caught up, because in the new year, it'll be, on the ground running, trying to keep up with this stuff. And I don't have a dog in this fight. I don't know what happened. And I'm not pulling for either team. I just don't know. I'm just praying that the truth comes out. And it's imperative that um, the truth does come out, because this is explosive and it's something that the church needs to know. And that's why we're covering it so closely and on it all the time. And we will be doing more investigatives and more court readouts on things that is happening with these, not just this case, but other cases if they come up. Prayerfully, they won't. Prayerfully, 2024 was the year of exposure of these churches, because, baby, We have had a lot of exposure, but if God is not finished, he's not finished, and let him do his will, for real, for real. Some of these questionable characters that is standing in the pulpit and leading his people, because God is not trying to play with his sheep. Time is drawing nigh, and he is pulling up the wolves up out of the house of God. So, anyway, I want you to like, share, and subscribe. Share, share, share. And remember that if you have not joined the channel, you can hit join and get all the um, pertinent, firsthand, exclusive information, because there's some things I'm not going to be sharing out here in the public, and some things that I will. There's a reason for memberships, and that is for you all to have perks. So I hope you join our channel. If you want to support us, you can support us below. If you look in the comment section, you'll see how to support us. But, we'll have another video coming after, my video. But I'm going to hope that you all have a wonderful year, the rest of this year, according to the Gregorian calendar. According to the Gregorian calendar. But again, you all be blessed. And as the old people say, don't take no wooden nickels. Be vigilant. And we will talk to you soon. Like, share, and subscribe. Thanks. Bye.
I'm writing lines to lift his name, no need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, let's amplify. I am spreading the faith I hold so dear. For every tear he's ever near. Choirs rise on Sunday morn, his love we adorn. Each melody a testimony, hearts reborn. In every